Your Honor.
Yes, ma'am.
We are ready. I forgot it's cut off.
All right, Mr. Schmidt, who are you ready on, sir?
Jason Bearden.
Mr. Bearden, you'll come up, sir. This is cause number CR 21-278, State of Texas versus Jason Kobe Bearden. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, we're not ready to proceed. I would ask for a reset on Mr. Bearden.
We want to set Mr. Bearden for the evidentiary docket, contested docket on February 20th or March 27th.
Optimistically, we can go for February 20th.
I'd agree, Your Honor. I think part of it is just going to be doing the math on credit time. Mr. Bearden may well be ready to go on the 20th.
Okay. All right, court will set Mr. Bearden on the contested docket February 20th at 1:30.
Talk to you soon. Thank you, Your Honor.
You're welcome, sir.
Brandon Creel, on down there.
State versus Brandon Ashley Krill, CR 23-158, CR 24-206. Sure, we are here on status of competency, and then I think we had a reevaluation, something of that nature. Go ahead, Mr. Schmidt.
Yeah, I believe Mr. Creel was reevaluated, found competent. We would adopt the latest finding, get Mr. Creel back on track, and we've been discussing possible resolutions with the state. So we'd ask for a reset for today. I guess we can go for that February 20th date as well.
Is that the date you want? I don't mind moving it out to March. I just didn't know.
I would prefer March under the circumstances.
Is Mr. Creel on any type of motion? Is he on a motion to revoke, motion to adjudicate, or is this a new underlying?
It's a motion to adjudicate.
In both cases, or is the CR 24-206 Berg of a Hab, is that a new charge?
I believe that's a new charge.
Okay, let's set Mr. Creel then for March 25th. And would that be docket call, Mr. Schmidt?
Yes, sir.
All right, docket call on each case.
Okay. It's my understanding he's on the forensic waiting list. If the court wants to remove him from that at this time, that'd be great. No objection.
I have a note that says removal order from the forensic clearinghouse list, so I'll need to check with Ms. Abraham to see if that means he's been removed, or we need to sign an order, or we need to.
She's telling me that an order needs to be signed, but I have no objection.
Okay, very well.
Joshua Blidwell.
CR 24-306, State of Texas versus Joshua Allen Gladwell for arraignment. Is that correct?
I don't think so. I don't know.
That's what I had it for. It was arraignment. Let me double check.
Yeah, well, we were going to try to plea Mr. Gladwell. We have a tentative agreement with the state, and the state is going to require some additional time to make sure that all of our ducks are in a row. So we would ask to set it for a plea, and I defer to the state on how much time they think we need.
Your Honor, if we could get right around the 20th, I don't want to drag it out any longer. In the meantime, though, I know we did have a bond hearing on Mr. Glidewell. his bond was reduced, and I believe he's still on that bond. So just as a matter of housekeeping, I don't know if he and Mr. Schmidt want to surrender that bond so that he's getting credit time while he's in here. Because he's in right now on some new charges, and that's what we gotta kind of do our homework on.
And Judge, we would agree with surrendering his bond if he's got one still active. And I believe Ms. Tabraham has suggested that my recollection is incorrect and that he has not been arraigned on the charge. We have seen the indictment and have gone through it. Everything is spelled correctly. We would waive formal reading of that and enter in a plea of not guilty at this time. I guess we could set up for a pretrial in the hopes that when we come back, we'll be ready to plea him out.
Okay. All right. Court finds that Mr. Goodwill has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record. Court sets this matter for pretrial hearing March 25th at 1:30. And if you work out a plea, then of course we'll do it that same day.
Yes, sir. Thank you.
Who's next?
Roy Mitchell. Oh, no.
Roy Mitchell III, CR 25-23 for arraignment.
Hey, Judge, we're ready. I've met with Mr. Mitchell. The indictment, his name spelled correctly, he understands the charge. We're in a plea of not guilty this time. Ask for that pretrial setting.
Right, court finding that Mr. Mitchell, having waived the formal requirements of arraignment, enters this plea of not guilty into the record. Court sets this matter for pretrial hearing March 25th at 1:30.
Oh, man, that ain't gonna work. Believe all the rest of my folks are pleased, Judge.
Okay. You
We
need
have
time.
we have two electronic, no, we're already signed up on two, and we have a paper plea on Mr. McDonald ready to go as well.
Okay, which one do you want to go with first?
I guess we can go with Jason McDonald with paper plea.
All right, Jason Wayne McDonald, CR 23-151. Mr. McDonald, sir, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, is your name Jason Wayne McDonald?
Yes, sir.
And Mr. McDonald, are you a United States citizen who reads, writes, and speaks English?
I am.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir. Very.
Do you understand everything that you have read and signed as part of your plea agreement?
Yes, sir.
Your signature that's in the document, that's your true and correct signature, and you only signed once you were confident that you knew what you were signing. Is that correct also?
Yes, sir.
Mr. Schmidt, do you believe Mr. McDonald to be competent today? And if so, have you explained to him his rights pertaining to this case?
I have, yes, to both questions.
And do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. McDonald, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. However, I find today that the state is recommending to the court that you be allowed to plead to a lesser offense, that being a Class A misdemeanor offense of assault causes bodily injury of a family member, which carries a range of punishment up to 365 days in the county jail and up to a $4,000 fine. I see that the plea agreement in this case, upon your plea of guilty, the state's recommending that your punishment be assessed at 196 days confinement in the county jail, for which you would receive credit for time served already. They're also recommending a fine of $750, court costs of $270, reimbursement fees of $570. In addition, the state is agreeing to reject a violation of a bond or protective order. Two counts of that, a count of resisting arrest, search, or transport, criminal trespass, burglary of a habitation, evading arrest or detention, and also count 2 of the indictment. Is that your understanding of the plea agreement, Mr. McDonald?
Yes, sir. Thank you.
All right, so let me ask you, Mr. McDonald, understanding the range of punishment, understanding the plea agreement, how do you plead to the Class A misdemeanor assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. McDonald, has anyone threatened, forced, or pressured you to plead guilty in court today?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, is there any objection to the stipulation of evidence supporting the plea?
Objection.
The stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance. Victim has expressed that she does not want us to proceed with the charges. However, given the litany, that's where we're at today.
Okay, and is this victim that you're referencing the same victim that's included in all of the 1245 violation of bond or protective order, burglary of habitation, the criminal trespass? Is that all the same victim?
It is, Your Honor.
All right, thank you, Mr. Harbaugh. Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and the recommendation of the DA's office. The court hereby convicts Jason Wayne McDonald of assault causes bodily injury of a family member. Court assesses punishment as a Class A misdemeanor at 196 days confinement in the Van Zandt County Jail. The court awards Mr. McDonald 196 days credit for time already served. In addition, the court assesses a $750 fine, $270 court cost, and $570 in reimbursement fees. The court also finds that the state is agreeing to reject 2 allegations of violation of bond and protective order, resisting arrest, search, or transport, criminal trespass, burglary of habitation, evading arrest or detention, and count 2 of the indictment. All right, Mr. McDonald, you are hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the deputy. And Mr. Schmidt, did you counsel Mr. McDonald on the payment of his fines, court costs, and fees once he is released, since he's not on probation?
Yes, sir, I did. I did tell him to meet with collections office of the district clerk's office, set up a payment plan. As soon as he gets out.
And did you also indicate to him that if he failed to do so, a warrant could issue for his arrest?
Well, if I forgot, he knows now.
Okay, very well. Who would you like next?
We have Heather McClellan. If you'd like to do that one, she should be ready to go.
Okay. Heather Dawn McClellan, CR 2522. And was Miss McClellan originally set for arraignment today?
Dude, I don't know. Was she? Miss Patty says she was.
Okay. Ms. McClellan, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Heather Dawn McClellan?
Yes, sir.
And Ms. McClellan, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any mental conditions?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir.
Do you have any questions before we go further?
No, sir.
And you understand everything that you have read and signed today, and you're telling me that when you sign the documents, that that is your true and correct signature, and that you only signed once you understood what you were agreeing
Yes.
to?
Yes, sir.
Okay, very well. All right, Mr. Schmidt, have you explained to Ms. McClellan her rights as they pertain to this case, the advantages and disadvantages of a deferred adjudication plea, and that if all of that being true, that she is entering into this agreement intentionally, knowingly, and voluntarily?
Yes, yes, to all of that.
Okay.
Yes.
All right, Ms. McClellan, you are charged by indictment with a second degree. Actually, you were charged with, was the indictment first degree or second degree? Because my docket says first, but
It's the first degree manufactured delivery. We're playing to a lesser second degree possession.
All right, Ms. McClellan, you were originally charged with a first degree felony offense of manufacture or delivery of a controlled substance between 4 grams and 200 grams. However, today it appears that the DA's office is recommending to the court that you be allowed to plead to a lesser offense of second degree possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams. A second degree felony does carry a range of punishment of not less than 2 years in prison and up to 20 years in prison, and a fine up to $10,000. I see that the plea agreement is upon your plea of guilty. The recommendation is that the court consider the evidence, not convict you, but rather place you on deferred community supervision for a period of 5 years, with the court assessing a $2,000 fine, $180 in restitution, $290 in court cost, $520 in reimbursement fees. And the state is asking the court to dismiss, along with your plea in this case, an unfiled forgery of a government or money or security instrument, and also a tampering or fabricating with physical evidence. Ms. McClellan, is that your understanding of the plea?
Yes, sir.
All right. Understanding all of that, I would ask you, how do you plead to the second degree felony offense of possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Ms. McClellan, has anyone threatened you, forced you, or pressured you to plead guilty in court today?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence supporting the plea?
No objection.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. Mr. Schmidt and Mr. Hartwell, in reviewing the stipulation of evidence, Ms. McClellan admits that she knew of the 14 grams of methamphetamine. Do you believe that's legally sufficient for care, custody, control? For possession?
I believe, Judge, that under the circumstances, I think what was trying to be articulated was that she's a co-defendant in the same vehicle, and that she was not ignorant of the location of the methamphetamine, which satisfies possession, particularly in a vehicle.
All right, the court, having considered the evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement today. The court hereby defers a finding of guilt on the second degree felony offense of possession of a controlled substance between 4 grams and 200 grams. The court places Ms. McClellan on 5 years community supervision orders her to pay a $2,000 fine, $290 court cost, $180 in restitution, and also $520 in reimbursement fees. And the court does dismiss under section 1245, unfiled DA case 2024-1101, forgery, and also DA 2024-1100, tampering or fabricating physical evidence. Ms. McClellan, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of this sentence. Before I have you step over to be fingerprinted, is this your first time on probation?
I've been on deferred probation before.
Okay, felony or misdemeanor?
Misdemeanor, I think.
So what's the maximum sentence you could be looking at if you don't do what you're supposed to do on probation?
I believe 20 years.
You're right, it's 20 years. So I want you to realize how serious that is.
Yes,
Now,
sir.
I don't know if you successfully completed your misdemeanor probation or not, but I want you to understand you're in a whole different ballgame now. In 20 years of your life, you seem to, how old are you? You appear to be a young woman. How old are you?
33.
33. All right. So getting out of prison when you're 53,
Yes.
that would be the majority, that would be the best years of your life.
Right.
Understand that? All right. So I expect you to be a model probationer, and if you're not, then they're going to let me know. And if they let me know, then that means you're going to show back up in this court. And I'd recommend you not do that.
Yes, sir.
All right. Step over to be fingerprinted.
Thank you.
You're welcome.
Just right there, you'll get you.
Mr. Schmidt, who's next?
This is Keith Stevens.
All right, this is cause number CR 25-14, State of Texas versus Keith Edward Stevens. Mr. Stevens, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Stevens, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. Is your name Keith Edward Stevens?
Yes, sir.
And Mr. Stevens, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions about your plea agreement before you go further?
No, sir.
Everywhere that you signed in those documents, are you telling me that that is your true and correct signature and that you only signed when you were confident you understood what you were agreeing to?
Yes, sir.
Mr. Schmidt, do you believe Mr. Stevens to be competent today?
I do.
And you've explained to him his rights pertaining to this case?
Yes, sir.
Y'all have also discussed the advantages and disadvantages of a deferred adjudication plea.
We have. Yes, sir.
All right, I see that Mr. Stevens was charged by indictment with a third-degree felony offense of assault of a family or household member with previous conviction, a third-degree felony, which does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, up to $10,000. Also see that the plea agreement is upon his plea of guilt, the court, considering the evidence, the DA's office is asking the court to defer a finding of guilt and place Mr. Stevens on 3 years of community supervision, along with a $1,500 fine court costs of $290, and reimbursement fees of $560. Is that your understanding of the plea, Mr. Stevens?
Yes, sir.
All right, understanding all of that, Mr. Stevens, how do you plead to assault of a family or household member with a previous conviction?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence in the stipulation?
No, sir.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance. Victim impact statement was sent out a few weeks ago, has not been returned. So we've been unable to make contact with the victim in this case, but we have made attempts.
Thank you, Mr. Harwell. Mr. Schmidt, anything further from your client?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of the offense. Court will follow the plea agreement today, the recommendation of the DA's office. Court hereby defers a finding of guilt for Keith Edward Stevens on assault of a family or household member with a previous conviction. The court places Mr. Stevens on 3 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $560 in reimbursement fees. Mr. Stevens, you hereby remanded to the custody of the probation department so they can carry out the terms or conditions of the sentence. I'm gonna have you step over to be fingerprinted.
I guess you kind of have to. I don't think it's gonna let go. I don't need a reset. Here's one.
All right, Mr. Schmidt, anyone else?
I think I have Preston Wilson. He's in federal custody. I guess we need to reset him or make an announcement.
Now, Ms. Abraham, you had a note in here that there was a U.S. Marshal transfer February 3rd. Guess that's when he went into federal custody?
Yes, Your Honor. That's what I was told by Henderson County.
Okay. You have any updates on that, Mr. Hartwell?
I didn't realize that he was just transferred in on the 3rd, Your Honor. We can certainly look into that. I know with this one, it's one of those cases where we kind of want to see what the federal system is going to end up doing. Obviously, we have him on manufacturer delivery 4 to 200. So if the federal system were to depending on what happens in that case, we may perfectly be willing to drop this, but we kind of want to wait and see what they're doing before we make that decision.
Are you in contact or can you be in contact with the U.S. Attorney's Office to find out and when their dates are, what they're planning on doing, so that we can set according. I don't mind waiting to see what they do, but I don't want to just every month set this and have to call and check. Is there any way that you can reach out or have someone in your office reach out to the U.S. Attorney's Office and see if they'd be willing to cooperate on giving us hearing dates and things like that?
Yes, Your Honor. Miss Curry's had some luck with some cases in the past, so I'll see if she's able to get some cooperation out of them in this case as well. I personally have never had success when I've tried, but I'll see if maybe one of her contacts is a little bit more forthcoming.
All right, then let's set Mr. Wilson. Let's just set him in April. No need in setting him in March. Doubt we'll hear anything from them by that time anyway. So how about Mr. Schmidt? You got your calendar available? Do you know there's a couple of Tuesdays? There's April 8th, April 15th.
I guess the 15th would be fine.
Okay. All right. Court sets Mr. Wilson then for status April 18th at 1:30.
Did you mean the 15th or the 18th, Judge?
I meant the 15th. I said the 18th and I wrote the 18th, but I meant the 15th.
Okay.
April 15th, tax day, right?
Yeah.
All right. Hey, Mr. Schmidt, on I think I don't know that did we dispose of the Keith Stevens other case? We did the assault, but there was a third degree injury to an elderly.
There's a
CR
motion to dismiss outright in the packet, so it should be disposed of.
Okay, I did probably not recite that, but if it was in the packet, then I signed it.
Yes, sir. In addition, he has a misdemeanor filed at Judge Winter's court. I have signed the motion, the 1245, and the motion dismissed to take down there. I think the state signed one as well, but it's on the electronic. I don't know how to get from that to Judge Winter's. So
If you can deliver that one to Miss Patty or Miss Peggy along with that paper plea, when I go to sign the paper plea, I can run it down to Judge Winter's court.
fantastic, we'll do that.
Okay. All right, so we need to wait on Miss Evans. Do we have any update on her, Miss Abraham?
She's here, Your Honor.
Oh, excellent. Okay, does she need time to talk with Miss Rankin?
Hi, Your Honor. I wondered if I could do a breakout with the state
Sure.
a proposed agreement.
Sure, absolutely. Give me just a second. I'll set that up for you.
Thank you.
You're welcome.
We'll have an empty courtroom in just a minute also.
Okay, sounds good.
Congratulations.
Your Honor.
Yes, ma'am.
All right, we are ready.
Do we lose the
Right.
rest?
All right. We are on record, cause number CR 20-354, State of Texas versus Tiffany Ann Rankin. We're here on a hearing on the motion to revoke. Any announcements, Ms. Evans?
Your Honor, here and ready, she waives formal reading of the motion to revoke her probation. I think based on our conversation with the prosecutor, we have an agreement to modify and extend.
Yes, Your Honor. Agreement is, don't have the exact days, but Ms. Rankin has approximately 4 months back time. We'd be eating up the back time, extending by 3 years and starting out on ISP. And then when probation determines that she's ready to go to standard probation, state would be unopposed to her going to standard.
And so do y'all have, are we doing this today or are we doing this another day?
Yes, Your Honor. State can get a motion to withdraw done here pretty quick. And my understanding is that probation can get a modification done pretty quick.
Okay, because you'll need the specific back time and credit. If you're going to take away the 120 days or so, then we'll need that laid out in there. So she's clear that should she later get a subsequent motion that she would not be entitled to that credit time, and it would help whoever's preparing the credit time in the future. Hopefully there won't be any preparation of credit time in the future, but if there were, it'd be easy to identify what she's entitled to and what she's not. So,
Yes, sir.
okay. And so do you want to just submit that to the courts with outside the hearing?
If the court's okay with that,
Okay.
we can certainly get working on that now.
Yes, let's do that. Ms. Rankin, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you can lower it again. All right, Ms. Rankin, you are currently represented by your attorney, Ms. Elaine Evans. Is that correct?
Yes.
And are you pleased with Ms. Evans and the work that she's done for you as your attorney?
Yes, I am.
Do you have any questions about this agreement that you're entering into with the state today?
No.
Ms. Evans, do you believe Ms. Rankin to be competent to enter into that agreement?
She is competent, Your Honor.
And you've explained to her her rights as they pertain to a motion to revoke?
Yes, Your Honor, I did.
And you believe that she's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, she is, Your Honor.
And so, Ms. Rankin, while I don't have the exact specifics in front of me in the form of a motion to withdraw with an order for me to approve, it's my understanding that your conditions of community supervision may be modified, that your length of supervision may be extended, and that any jail time that you have done on the basis of being arrested on this motion to revoke would be considered a condition of your community supervision as a part of this agreement, meaning that let's just say you had 130 days or 120 days of back time credit, then it'd basically be this court would be ordering you to serve all of that time as a condition of your community supervision, which means that should we end up in this situation again, and if you are ever revoked on that and you are given a sentence on this third-degree felony, you would not be entitled to any of the time that you have already spent in jail on this cause. For instance, if the court assessed a sentence anywhere between 2 years up to 10 years, I'm not even sure what I don't have the motion in front of me. What was the original sentence on this, Ms. Evans?
She was sentenced to 5 years, probated for 2, or
Three.
probated for 3.
Okay, so if the court assessed the sentence between the minimum 2 to the maximum 5, then you would get credit for the time that you have spent in jail, not served as a condition of your community supervision. Does that make sense?
Yes.
Okay. And so that's another way of saying that is any of this time that you're doing as a condition as part of this motion to revoke would be pulled out of any other credit time that you may have towards any sentence that you got in the future.
Okay.
You understand that?
Yes, I do understand that.
And so, 3 to 4 months of credit time is a significant portion of time. So while we're all optimistic and hopeful that you will not be in that situation for that to be an issue at all, it's one that you must be admonished about and be clear on so that your agreement today is voluntary, meaning that
I won't get that back time, basically.
you would not get that back time. Yes.
Okay.
You've said it in a much simpler way than I did. But Yes, you're right.
Okay,
You would never get that as a credit again.
okay, that's fine.
Okay,
It won't be a problem.
I hope you're right. I
He's
hope,
going to be successful.
well, and you're the one that will determine that. So, so we can hope to trust you on that. Okay, all right, then, Mr. Hartwell, I will allow you to submit your motion to modify and extend with your in agreement with Ms. Rankin and Ms. Evans. Submit that to the court and I will get that signed. And as soon as we get that signed, then she can get processed out of custody.
Thank you,
Thank
sir.
you.
Thank
All
you, Your Honor.
Ms. Evans, anything further?
Nothing further.
All right, thank you, ma'am.
Thank you.
You're welcome.
Okay, Ms. Evans is going to come to the courthouse to sign the papers. And then I will, after you've signed them, I'll send them out here.
Are they going to be here or? You want to just go to the, where are they going to be? Are you talking about the probation papers or the? Okay,
Probation. Correct.
if it's going to be a motion to withdraw, no one needs to sign anything except Ms. Rankin. She's going to be the one signing her extension. Ms. Evans shouldn't have to sign anything if it's going to be a motion to withdraw in order. So
Okay.
Mr. Hartwell will file, he'll send that motion to one of us or e-file it or whatever, and then I'll sign it. And then the modified conditions of community supervision will be signed by Ms. Rankin prior to her being out of custody, is my understanding. Correct, Ms. Burns?
Ms. Matura.
Oh, I'm sorry. Correct, Officer Matura? Or does she usually sign once she gets out of custody and comes into your office?
Normally it's prior.
Normally it's prior to being released. Okay, so yeah, that's my understanding as well. She'll remain there until she signs her conditions and then she'll be released. Okay,
Thank you, Your Honor.
you're welcome. Ms. Abraham, anything further?
No, sir.
All right, then that concludes our criminal docket. Court is adjourned.
Thank you, sir.
Thanks, sir.